Case number 24 CR 127, State of Ohio versus Scott Nicely. Present for the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Sarah Barker. So I believe this matter is set for an intervention in lieu of conviction plea. I don't see any paperwork.
It should be in the PSI file, Your Honor. We had started this.
Oh, that's right. We held on to it because the last time. That's right. And there it is. All right. So you are Scott Nicely?
Yes, sir.
All right. I believe we continued this last time because we didn't have the assessment, and I see here now that we have a assessment from Scioto Paint Valley Mental Health Center. And looks like this was completed on December the 2nd. And have you started your sessions yet, Mr. Nicely?
Yes, sir.
When did you start?
Last Thursday.
Last week. Were you doing 3 days a week?
Yeah.
All right. All right, so Mr. Nicely, the proposal I have here, the plea agreement, is for you to plead guilty and then be placed into what's called the intervention in lieu of conviction program. And this is with the entry, a 4-page document. On page 3, there's a line that says, "I enter this plea voluntarily," and right below that, there's a signature, Scott Nicely, with the date of 10/23/04, with your attorney's signature below. So you signed this document
Yes, sir.
almost 2 months ago, and at the time you signed it, you understood it's an agreement to plead guilty.
Yes, sir.
All right. Now, I'm sure your attorney's gone over this with you, but I need to explain it to you on the record. Normally, under the law, if a person is convicted either as a result of a trial or a guilty plea, they are then sentenced. And once the sentencing entry is filed, that person then has a criminal conviction. Now, when there's a plea of guilty, even though it's in the file, the person is not considered to be convicted until the sentencing. And so what happens in a case such as this, an intervention in lieu of conviction program, since you are in a certified treatment program for Scioto Paint Valley, certified and licensed by the state, and there's an agreement from the state that your substance use disorder was a contributing factor to your offense, the law allows a person to go into a treatment proceeding where you have to complete your treatment program, and you must comply with certain supervision conditions that the court has for this kind of a program, which are not as significant, not as many of them, and are not as severe and limited as it would be if you were convicted. Now, the court can put you under this program for a period of up to 5 years. I typically do 2 because I think that's enough time for a person to determine if they're going to stay sober and clean, and so I only go 2 years. Now, you must comply with your treatment program, so you would have to complete the program that's Scioto Paint Valley and any other future programming that they recommend. You would also have to, as I say, comply with the conditions of supervision. One of the conditions of the statute is you must remain alcohol and drug-free for a period of 1 year, even though alcohol, I don't think, was the issue here, but sometimes people turn to alcohol when they aren't using drugs. Well, and that's still a means of self-medicating, and it's not something that any person that has a substance use disorder should do, because they're all considered substance use disorders. You're just trading one kind of substance for another, so that's not accomplishing anything. So that's why alcohol is involved. Now, the exception to that is if you have a prescription, a lawful prescription for the substance from a doctor. It doesn't include medical marijuana, and you can't get legal marijuana because, again, those are substances. Same way as alcohol is legal, but you can't get that. You can't use that because of this. And so, if you comply with those conditions, You stay in compliance with your treatment program, you don't use or drink for at least 1 year, and you comply with the conditions of supervision and pay your court costs. When the court is notified of that, the case is dismissed. And so even though you pled guilty, you don't have a criminal conviction for this offense. And so if somebody looks at your record while you're on this program and they say, well, you're a convicted felon, you say, no, I'm in an intervention program, so I have not yet been convicted. And that's what the law is. And so that's what the benefit is to you. You get this opportunity to, get clean, stay clean, comply with community control, and get your case dismissed. Now, the disadvantage to you is if you don't make it, you don't get to come back here and say, well, that was worth a shot, let's have a trial now, because you're pleading guilty. So that's why we're going through this whole process. Now, if you are granted the intervention and the probation feels that you're not compliant, they have to file a written allegation of that with the court and give you a copy. And then there's a hearing, and at that hearing you'll have an attorney. If the outcome of the hearing is that you fail to comply, then at that time the court would find you guilty, and then you would be subject to being sentenced. And this agreement indicates that you understand that for this offense, aggravated possession of methamphetamine under 2925.11 of the revised code, it is a 5th-degree felony which carries a possible term of incarceration of 6 to 12 months, a fine of $2,500, and a license suspension up to 6 months to 5 years. So if we have that hearing, it's found that you didn't comply, then you are terminated from the intervention and you're found guilty, and then at that time you do get sentenced. It could be any of those, or it wouldn't have to be any of those. It could still be community control or probation. And like intervention, that could be for up to 5 years. Now, if that happens, those conditions are much more restrictive, and there are more of them. But basically, it works the same. If the probation department feels that you're not compliant, then they have to file that written notice. We have a hearing. You're entitled to an attorney. And then if the outcome of that hearing is that you fail to comply, then the court could then revoke your community control and then sentence you to the term of incarceration. And if you get revoked because you committed a new criminal offense in either of these proceedings and you are sentenced to prison, then you could be sentenced, if you were sentenced to prison on this case, consecutively to the new charge. Now, you understand all that?
Yes.
Okay. Now, under the law, if you should be sentenced to prison at some time in the future on this charge, the Adult Parole Authority does have the option under the law to put you under post-release control supervision for a period of up to 2 years, which means you'll be supervised by a parole officer. And if the parole authority determines you've not complied, then they have the right to return you to prison to make you serve as a sanction an additional period of up to half of your prison term for one or more violations. But if your violation is a new felony, then in addition, whatever sentence a judge in the new case could impose upon you, that judge would also be authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively, a sentence in the new case. You understand that?
Yes, sir.
Okay. Now, the charge is that on or about December 13, 2023 in Highland County, Ohio, you knowingly obtained, possessed, or used Schedule II controlled substance methamphetamine. So that's the felony 5 that we've talked about, the penalties. You understand what it is the state's accusing you of having done, when, where, how they alleged you did it?
Yes. Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his or her advice and competence in this matter?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
No.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Now, other than being promised that the state would recommend you be granted intervention, which would be the court's intention in lieu of conviction, has anyone promised you anything other than that?
No, sir.
Now, do you hold any kind of a license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
All right, now, again, since this is your last chance to stand on a not guilty plea and defend against the charge and have a trial, I have to explain to you your constitutional rights. So first of all, you have a right to counsel. Ms. Berger was appointed to represent you. That wasn't simply to work the case out, but provide any defense that might be available to you under the law that you would like her to provide. So if you decide you do not want to do this, then she will still represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, the judge will instruct them on the law, and then that jury would decide by a unanimous verdict whether or not the state proved your guilt. And that verdict, again, would have to be unanimous, meaning all 12 would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that would be to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Niely, you have the right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, court issues a subpoena, which forces those people to come to court, to be able to testify even if they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Right now, under the law and the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence against yourself in the proceeding at any time, including trial. No one can ever make you testify about this matter. Prosecutor can't, the judge can't. It's totally up to you. If you decide to exercise that right not to testify, the fact that you do not testify cannot be used against you in any way by any person at any time in the proceeding. And in fact, no one's even allowed to talk about it, with one exception. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Niely, you're presumed innocent of this charge till proven guilty by the state of Ohio on every essential element of the offense charged. So, what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Originally, you pled not guilty. Not guilty plea denied the allegation, denied in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just discussed. If you change your plea today, from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed the crime. And that plea waives, gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives or gives up your right to a jury trial or a court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney in open court. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. Waives, gives up your privilege against self-incrimination because you're the one that's saying you're guilty and that's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It would subject you to being sentenced immediately by the court, but we're not going to do that today because we're going to go through the intervention process. And finally, it waives, gives up any right to file an appeal you think you may have had in this matter up until this point in the case. Now, if in the future I should sentence you the maximum sentence, or depending upon what would happen in the future in the case, you may have a right to an appeal. That would have to be filed within 30 days of your sentencing entry being filed. But it will only occur once you've been sentenced. You understand that?
Yes, sir.
All right. And are you a U.S. citizen?
Yes, sir.
And are you entering into this plea agreement going forward today and waiving your rights voluntarily?
Yes, sir.
All right. Do you have any questions about this process, what's going to be expected of you?
No, sir.
You understand?
Yep.
Any questions about the charge and the possible penalty?
No, sir.
You understand?
Yes, I do.
Any questions about the plea agreement?
No, sir.
You understand it?
Yes.
Any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Any questions about the plea of guilty, what it will mean if you go forward into that plea here this morning?
Yes, sir.
Do you have any questions?
No,
Okay, now do you understand?
I'm sorry.
You skipped ahead of me. Yeah. You understand?
Yes.
All right. Anything you need to speak to your attorney about before we go any further?
No, sir.
This is your decision to go forward with this plea agreement, plead guilty in exchange for being recommended to be granted intervention in lieu of conviction. Is it your decision to go forward and plead guilty?
Yes.
Excuse me. All right, then as to the charge which alleges on or about December 13, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, fifth degree felony, carrying a possible prison term of 6 to 12 months, a fine of $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Thank you. You can be seated. All right, the court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept and ordered filed. Now, the court finds that the parties have stipulated that the defendant's drug usage or other factors as set forth in a statute was a factor that led to the commission of this offense, and that intervention in lieu of conviction will not demean the seriousness of the offense and would substantially reduce the likelihood he will commit any future criminal activity. He is accepted into an appropriate certified treatment plan through Scioto Paint Valley Mental Health. He's otherwise eligible for community control. He's not a repeat or dangerous offender, and meets the criteria as indicated earlier for this program. And so therefore, although the court does accept the guilty plea, it will not make any finding at this time, and instead the proceedings will be stayed. Stayed just means they're stopped, and we wait a report. And you'll be under community control under the conditions set for the intervention in lieu of program at the probation department by the court. They will go over those with you, and you'll get a copy of them and have that explained. It's required that you successfully complete your intervention plan with Scioto Paint Valley Mental Health and any future recommendations that they make, including the requirement you abstain from using drugs or alcohol for at least 1 year, and you're to comply with all the terms and conditions that I have previously indicated are set forth by the county probation department. In the event that you successfully complete your intervention plan and obey all the conditions and pay court costs or fees, any fees that may be assessed for any programming, then after that, the court, upon notice of that, will dismiss the charge. And that means you will never have a felony conviction, and in fact, the court will set that for a sealing hearing to seal the record, provided that everything has gone according to plan and there's been no subsequent criminal activity. It's ordered that you pay the court costs, including an additional $50 that will be paid in advance for your sealing fee. Now, in the event that the probation department feels you're not compliant, they'll file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney, and you will have an attorney. And if the outcome of that hearing is that you're guilty, then at that time, you've violated the program. At that time, you'll be terminated from the intervention plan. You'll be sentenced according to what I explained to you earlier, and that could include as much as 12 months in incarceration and a fine of $2,500 and a license suspension of 6 months to 5 years. And then you'd be, at that time you would have your felony conviction. At that time you would be entitled to file your appeal that I explained on what basis you could. All right. Now that completes the case, so you're no longer under pretrial supervision, house arrest, or any of that. You're going to be under these new conditions. You'll need to report to probation. I think I saw, Officer Benson and Sturgill are both here. So check with them before you leave to see when they want you down there to be transferred over to the new program. Okay. All right. Anything further, Counsel?
No, Your Honor.
No, Your Honor.
Thank you. Christopher Holt.
Today.
All right, this is case number 24, CR 128, State of Ohio versus Christopher Ernest Holt. Present for the state's Assistant Prosecutor King, present on behalf of the defendant, Attorney Sarah Barger. And are you Christopher Ernest Holt?
Yes, sir.
All right, Mr. Holt has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The matter was referred to the drug court docket, the probation department. I've received the report and indicating Mr. Holt does meet the criteria and has made application for the program of drug court. Anything from the state regarding sentencing?
Thank you, Your Honor. The state would ask that the court follow the joint recommendation and place the defendant on community control. This defendant is currently on post-release control and is also in community control out of this court for another case. Thus far, his attempts at community control have been fairly minimal. Ms. Sturgill has secured a bed at STAR for this defendant on December 31st. I do believe he could benefit from the STAR program and would ask that he be ordered to complete the same. That's all. Thank you.
All right, Ms. Barger.
Just what is contained in the plea agreement, Your Honor?
All right, so Mr. Holt, you're down at the Recovery Council now, right?
Yes.
And you made an application for the drug court and talked with Ms. Sturgill.
Yes, sir.
Now, under the law, I don't sentence people to participate in the drug court. I admit that they have to want to do this. You're on community control now in your other case, and if I put you in on this case, it'll also apply to that case. I'm going to transfer that case as well. Now, the purpose of regular community control, which you've been on, is basically conditions that are designed to make sure that you don't commit another criminal offense, stay out of prison. You haven't done very well on that. The difference between that and community control or drug court is that the drug court program is a much more intensive program. You're tested regularly while you're in residential treatment. You're subject to being tested any time. Once you're out of your treatment facility, you could be subject to being, well, you will be subject to being required to call in and find out every day to see if you're going to be tested. You're usually tested about 3 days a week for a while until a period of time passes where you're clean. And they're much more intensive programming and restrictions. Now, the one thing about drug court is that there's a lot more resources that are available to assist you and give you tools for which you can rebuild your life. The focus of drug court is to keep you sober and to help you start, as I said, gaining the life skills or regaining the life skills that you've lost because of your behavior or failed to acknowledge or learn, and allow you to rebuild your life. And because the focus isn't on keeping you out of prison, but on you changing your life, that's a whole different approach. And you have to be committed to that. And I'll tell you right now, the drug court's way harder than community control. Because there's sanctions if you don't comply, and you're looked at and talked to all the time. Yeah, and it's going to be at least 18 months, and you'll go from residential treatment to transitional, and then possibly to sober living before you get back into independent living. It'll take time, and it takes patience, but it takes commitment. And if you're not committed, just tell me, and we won't waste your time or our time. And we'll just go ahead and move forward and see what happens with you on community control, which hasn't been good. So, you understand that?
I do.
And is that what you want to do?
I do.
You want to be in the drug court? Okay. All right. Then the court will order that the defendant be transferred, or that his case be transferred to the drug court, both this case and 22 CR 243. And that he be required to comply with those with the following conditions. You're sentenced to community control for a period of 3 years under the drug court docket. You're required to comply with all of the requirements and the conditions set forth in that description and attachments which you were given. You went over with the probation department. And I'll highlight some of those. You're required to comply with everything, but these are the ones that I'm going to highlight for you. If I don't mention them in my discussion and they're in the conditions, you still have to comply. First of all, you're to obey all laws of all jurisdictions, conduct yourself in all body manner at all times. Must report when and as directed, be truthful in all statements you make to the probation department. You must keep them informed of your residence and place of employment at all times, may not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. You have to have that on your person when you're traveling in a different state. May not enter upon the grounds of any correctional facility or communicate or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. Now, because of your conviction, both in the other case and this case, under both federal and state law, it's a crime for you to purchase, possess, own, use, or have under your control any firearm, ammunition, or dangerous ordnance. And if you did that, you could be prosecuted. It's also a condition of the probation conditions that you not have any of those or any other weapons while you're on community control. You may not purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any type of a controlled substance or drugs that are being sold over the counter that has effects that are similar to those. Even though they may be technically legal, you may not have those because it interferes with your sobriety and your recovery. You're not permitted to have any instrument, device, or thing that may be used to administer those unless you have a lawful prescription for the device. And you can have drugs, controlled substances, or drugs abuse that are legally prescribed, but again, you'll find it in procedure before you get that prescription. You have to disclose that to the doctor. He or she has to sign a receipt that's returned that shows they are aware of that before they issue you the prescription. You're not permitted to purchase, possess, or use any type of alcohol beverage or be present in places where they're sold or being consumed. May not associate with anyone who was a co-defendant, if there was anyone, or any person who is a member of a gang, has a criminal record, or any other criminal member of any other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. That would also apply to any family members that may fall within that definition unless you were living with them immediately prior to the commission of this offense. Now, to the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or the charge of violating the law not later than the next business day after that occurs. You'll provide financial information once you're working to the probation department so that they can assess your ability to pay any restitution, fees, or cost, court costs that are required. If you're referred by probation during this program or during this time, or even your treatment, anybody in your treatment team, to be evaluated or assessed for further programming, treatment, therapy, etc., you just submit to that, and if there's a recommendation you do that, then you are required to do it. You'll pay the court cost and make payment arrangements to do that. And by being placed on community control, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you or used by you, or any other property or place that is under your control where you're found at any time, any member of the probation department. And you'll have to sign a written consent for that acknowledgement so that it will be in the file. Now, in the event that is alleged that you have failed to comply, the probation department will give you a written notice of that. There will be a hearing. If the outcome of the hearing is that you have failed to comply, at that time you could be terminated from the drug court program, reinstated to the regular docket, and then sentenced to a period of 6 to 12 months, fined $2,500. And if that occurs, that would have to, and if that occurs because of a conviction in another felony case and you're sentenced to a term of imprisonment in that case, the sentences in that case, in this case, could be ordered to be served consecutively. And if that occurs, completion of the sentence, it is possible the adult parole authority would place you under post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, then you'd be supervised, and if they found you failed to comply, then they could return you to prison and make you serve an additional period of up to 9 months for a single violation, although there is a cap or limit of half of the prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence a judge in that new case can impose, that judge could also sentence you for committing that offense under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your
All
Honor.
right. That, again, completes your case. You're off for pretrial supervision, house arrest, et cetera. See you probation on the way out.
Thank you, Your Honor.
Thank you. Case number 24, CR 126, State of Ohio versus Dylan Aaron Downs. Representing the state is Assistant Prosecuting Attorney King. Representing the defendant is Attorney Danielle Witt. And are you Dylan Aaron Downs?
Yes, sir.
All right, Mr. Downs has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The court ordered a pre-sentence report. I did receive that. And have each of the attorneys had an opportunity to review the summary?
State has, Your Honor.
Yes,
All
Your
right.
Honor.
The matter was referred to the drug court for consideration, and Ms. Sturgill did send a letter to the court indicating that because he has reported that he'd been clean for over 11 months, his assessment was that he would not be eligible for drug court because he didn't meet the risk threshold. Although he is has been assessed by Reach for tomorrow and is scheduled to undergo monthly reporting as a prophylactic measure, preventative measure. So, with that, Mr. King, anything from the state?
Only was contained in the plea agreement, Your Honor.
All right, Ms. Witt.
Yes, Your Honor. We also asked the court to follow the recommendation in the plea agreement. While Mr. Downs did not meet the criteria for drug court, I think it's for one of the best reasons possible, and that is that he is clean now, and he has been so since before this incident happened, which just happened in January of last year, or this year, so almost a year ago. So we just asked the court to place him on community control and feel that he would be amenable to that and to continue him and Reach for tomorrow as well.
All right, Mr. Downs, anything you'd like to say?
No, sir. Other than Reach, they had me come in and I ended up doing my evaluation with them. Reach really didn't want me to stay in the program, only because they said that I didn't have a drug problem and I worked 6 days a week. So they said there was really no point in me going to the Reach program. They said if anything, they could do like a phone call interview thing with me to check in with me and chat with me every week, if that was possible.
Okay. Well, I know that you went into the STAR relapse program from Ross County after you completed STAR in 2023. Then you apparently violated that. I probably was this incident here, which I believe happened in January of 24. And it says here you started, so apparently when did you go into STAR relapse? At the end of January?
Yeah.
Okay. It says you were successfully discharged on 4/28. And have they terminated you from probation there?
Yeah.
You're not
in Ross
alone.
County, I'm done.
Okay. All right. Well, Mr. Downs, I'm going to go ahead and order that you be placed on 3 years, sentence you to 3 years of community control under these conditions. You obey all laws, all jurisdictions, conduct yourself in law, body, manner, all time. Report when and as directed, be truthful in all statements you make to probation. You must keep them informed of residence, place, of employment at all times, may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You must have that on you when you're traveling out of state. You may not enter upon the grounds of any correctional facility, nor may communicate or attempt to communicate with anyone who's an inmate in those facilities without prior permission in writing. Because of your conviction, you're prohibited under both federal and state law from purchasing, possessing, owning, or using, or having under your control any firearm, ammunition, or dangerous ordnance. If you do that, you're subject to being prosecuted for a felony under both federal and state law. It's also a condition you not have any of those or any other types of weapons while under community control in this case. You're not to purchase, possess, use, or have under control any kind of a controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substance or drugs abuse, nor any instrument, device, or thing that may be used to administer them or prepare them for administration, unless you have a lawful prescription for both the substance and the device or equipment. You're to submit to drug testing when it has directed. Not purchase, possess, use, or have under control any kind of alcoholic beverage or be present places where they're sold or being consumed if it's otherwise lawful. Not to associate with anyone as a co-defendant or any other person as a criminal record, a member of a gang or other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions unless approved in writing by your supervising officer. And that applies to any family members that fall within that definition unless you're living with them immediately before the commission of this offense. You may not, after the date of this order, marry or establish cohabitation or common law marriage type relationship with another without written permission. Must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. Must provide the probation department with financial information records so your ability to pay any fees, costs, or programming fees can be reviewed. If you're referred by the probation department for any other evaluation or assessment for further treatment, therapy, counseling, training, or other educational programming, you're to submit to that. If they recommend any programming, you're to enroll in and successfully complete that. I'd strongly urge you to meet with REACH or some other type of support group, provide proof you're doing NA or AA meetings or something, because I'm just going to tell you right now, you can't do this on your own unless you really work on it all the time. And that includes peer support, includes going to meetings and so forth. You already relapsed once.
Yeah.
Luckily, you didn't go to jail or prison for it. And the fact that you're clean right now, that's great. But I just can tell you, life is not easy for anybody. And when you have a history of substance use disorder, you're very high risk to relapse. And that relapse might involve new criminal cases, which means then you're probably going to go to prison because you've been in probation down in Ross County, you're on probation here now, and so what I'm telling you is, if somebody tells you at the probation department, I want you to go to meetings, or I want you to provide me proof of what you're doing to stay sober, you need to do that. People just don't get sober and say, okay, I'm done, and the rest of my life's going to be good. It's a daily struggle, and so you, right now, are doing that with a very limited amount of effort, and that is lucky, if so far, that you stayed clean. But I just want to tell you, things will get tough, life will get tough, you'll have stressors, you'll be subject to temptations and meeting people, places, and things where you used before. So I think you're at a very high risk to relapse unless you're in treatment. So I think you want to reevaluate that. I know you work a lot, but I can tell you this. When I first started this job, I thought people working every day, that would keep them sober. Well, I found out pretty quickly that I was way wrong about that, because we have people that work every day that abuse drugs. You read about them overdosing in their trucks at work, or out in the parking lots of factories, or in the back room of a store where they're working. So people can still use and hold a job. So that fact alone isn't going to keep you sober. I'll just tell you that right now. So, and if that's the excuse, well, I can't go to treatment because I'm working too much, what I tell people in drug court is, you have to take care of yourself first, and that means take care of your addiction before you worry about taking care of anybody else. So if they're telling you to get additional evaluations, and again, maybe that you don't need to do it, but you'd be an exception to the rule. I'm just telling you that right now. All right, now, you're to pay the court costs and make payment arrangements to do that. Now, by being And you're to comply with any recommendations of the REACH program and any aftercare they recommend. If they're not recommending anything further, that's okay, but again, probation will monitor that. Now, by being put on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place where you're found at any time by any officer of the probation department. You're required to sign a written acknowledgement of that and consent to be put in the file. There'll be no fine or driving suspension. You're also ordered to pay the court costs as a substantive order. If you don't, it's an order of the conditions that you make payments. And if you don't, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. They could refer it to collections, which means then you'd have to pay 30% fee to the collection agency on top of what you owe. So it just makes it worse if you don't keep up the payment plan. And if that doesn't get it, then the court can order you to do community service in this county and give you credit and hourly rate set by the court until you work that off. Now, in the event that the probation department feels that you're not complying with this order, they will file a written notice out to the court, give you a copy. There will be a hearing. You'll be entitled to have an attorney. The outcome of that hearing is that you have failed to comply. Then the court can terminate you from community control and sentence you to a term of incarceration between 6 and 12 months, fine you $2,500. If the incarceration is to a prison, upon completion of the prison term, adult parole authority could put you under post-release control supervision for a period of up to 2 years under terms they set. If they do that, you violate those conditions, they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition, whatever sentence could be imposed by the judge. In that case, that judge could also sentence you for committing that offense under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater, and that would run consecutively to the sentence in the new case. All right, is there anything further from counsel? All right, this completes your case. You're no longer under pretrial supervision, house arrest, etc. You're under the new conditions. See the probation department. You'll report down and get a new, be supervised under these new conditions.
Okay.
All right, thank you.
Thank you.
Chase Huntsman. Pressure this morning. We got started late, or this late, because I've got a real tight schedule today. All right, case number 24 CR 135, State of Ohio versus Chase Aaron Ray Huntsman. Present for the state is Assistant Prosecutor King. Present for the defendant is Attorney Sarah Barger. And you're Chase Aaron Ray Huntsman.
Yes, sir, Your Honor.
Mr. Huntsman has entered a plea of guilty to aggravated trafficking in drugs, a fourth-degree felony. The matter is referred to the probation department for a pre-sentence report. I have received that. Each of the attorneys had an opportunity to review a summary.
The state has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation and place this defendant on community control. There is restitution in this case to the task force, and that would be in the amount of $240. That's all. Thank you.
Barger?
Just what is contained in the plea agreement, Your Honor. My client is aware of the restitution.
Anything you'd like to say, Mr. Huntsman?
No, sir, Your Honor.
All right. It is the order of the court that you be sentenced to a term of 3 years of community control under the supervision of the probation department under these conditions. You obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed. You must be truthful in all statements you make to the probation department. You must keep them informed of your residence and place of employment at all times, but not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission, and you must have that pass on you when you are in the other state. You're not permitted to enter upon the grounds of any correctional facility, nor communicate with or attempt to communicate with anyone as an inmate in those facilities without prior permission in writing. You may not, because of this conviction, purchase, possess, own, use, or have under control any firearm, ammunition, or dangerous ordnance. If you do, that's a violation, felony violation under both federal and state law for which you can be prosecuted. It's also a condition that you not have any of those items while under post-release or under supervision in this case, nor any other types of weapons like knives and hatchets and things like that. You're not permitted to purchase, possess, use, or have under control any controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any type of a controlled substance or has effects similar to those without a legal prescription. And you may not have any device, instrument, or equipment that would allow you to use those or prepare them to be used unless you have a lawful prescription for both. And you must provide copies of that to your supervising officer within 24 hours of the receipt. You must submit to drug testing when and as requested. You may not purchase, possess, use, or have under control any alcoholic beverage or be present in places where they're sold or being consumed, even if it's otherwise lawful. You may not associate with anyone who is a co-defendant in this case, or any other person that has a criminal record, is a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless approved in writing by your supervising officer. That applies to any family members that might fall in that definition unless you were living with them immediately before this offense was committed. You not after the date of this order marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement, any arrest, citation, conviction, or the charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for an evaluation or assessment for any further type of programming, treatment, therapy, etc., you're to submit to that. If there's a recommendation for programming, you're to enroll in and successfully complete that. You're to pay the court costs of this action. Are you employed?
Not at the moment, Your Honor.
All right. You're ordered to do 400 hours of community service at the rate of 20 hours per week for 20 consecutive weeks unless you're employed at least 20 hours a week. You're a full-time student, or you have documentation by a physician or prior disability finding that you're physically unable to do that work. You'll be required to pay the restitution and monthly payments, $20 per month beginning April the 1st of next year. And you'll pay any, and that's payable, $240 is ordered to be paid to the Hyde County Task Force through the Victim Restitution Escrow Account and the Victim Witness Office, and you'll pay any service fees connected to that. You're to successfully complete the REACH program and any aftercare that they recommend. And I'm abbreviating that. It's your substance use disorder treatment. And the order is SUD, stands for substance use disorder. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other place where you're found. At any time, any officer of the probation department, you'll sign the written acknowledgement of consent for that at the probation department. You'll not be required to pay a fine or driving, there'll be no driving suspension. The court costs are also ordered to be paid as a substantive order. If you fail to make payments on those, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, the clerk can refer that to the to a collection agency, and then that would subject you to be required to pay in addition to the cost and the 30% collection fee allowed by law. In the event that that doesn't collect it, then the court can also order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you're not complying, they would file a written notice with the court, and there would be a hearing. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and sentence you to a term of imprisonment of between 6 and 18 months and fine you $5,000. And if that revocation was due in part or whole due to a new felony conviction and you were sentenced to a prison term on that charge, the sentences could be ordered to be served consecutively to each other. In the event that that occurs, it is once you complete your prison term, the adult parole authority is authorized to put you under post-release control for a period of up to 2 years if they decide to do so. It's optional. And if they do, you'll be supervised by a parole officer under the terms they set. And if they determine that you have failed to comply, they can return you to prison as a sanction to make you serve up to 1/2 of your prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence a judge in a new felony case can impose upon you, that judge would also be authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to sentences in your case. All right, is there anything further, counsel?
Restitution ordered.
Yes, $240, $20 per month through victim witness.
That's all, Your Honor.
All right.
Nothing further, Your Honor.
All right, that completes your case then, Mr. Huntsman. You're no longer under pretrial supervision or house arrest. You're under the new conditions. See probation officer Benson over there for appointment as to getting transferred to the new program. All right, thank you.
Thank you, Your Honor.
All right. All right, this is case number 23CR29, State of Ohio versus Jennifer M. Baker. Are you Jennifer M. Baker appearing there from DCI 3?
Yes, I am.
All right, you can hear me okay?
I can hear you. Can you hear me okay?
Yeah, I'm turning up the volume here. Your attorney is Mr. Bolger. He is present here in the courtroom, and so is Assistant Prosecutor King on behalf of the state. This is a hearing for considered judicial release. Ms. Baker was sentenced to a term of, I believe, 24 months, and that entry was filed on June the 2nd, 2023 originally. Then it was, she did go in for a short period of time, then the court released her on bond pending her appeal, and she ultimately was required, after the conviction was affirmed, to execute her sentence. And I believe that would have been June or July of this year, I believe. I have that date down here somewhere in my notes, but I can't. Do you recall when you went back in? It looks like June 30, 2023 in Mr. Bolger's motion. Is that correct, Ms. Baker?
I went in June of 2023 and spent 6 days, and then I returned on April 29th of this year.
April 29th, yeah. All right, yeah. I should have read on further. April 29th is when you were returned, and I think you were actually in custody for a few days before that. All right. So, Mr. Bolger.
Well, Your Honor, we have made arguments in favor of the motion and the memorandum in support of the motion and the supplemental memorandum. The PSI in this particular case indicates you're dealing with a person who has an unusual level of education and life experiences for a criminal defendant coming through this system. She has substantial skills in accounting and finance, and she's used them to occupy positions of considerable responsibility, both in for-profit and non-profit institutions, two of which are in this county, where she worked for over 2 decades, I believe, for community action. She is, in my opinion, well worthy of the court's consideration on this motion. It's hard for me to identify what interests of the state are now being vindicated by further incarceration. She, I believe, presents a minimal risk of any recidivism. She has, through her life, a desire and an ability to accomplish significant things for herself and for the community. And I think the community would be benefited by her early release.
All right, Mr. King, the victim of this offense has been notified of the time, place, purposes hearing.
Yes, he has, Your Honor.
I saw in your memorandum you had discussed it with him. I will make sure.
He's not present today. I believe he's likely monitoring the hearing on YouTube.
All right. Now, anything you'd like to say, Mr. King, on behalf of the state?
Thank you, Your Honor. The state would be opposed to the defendant being granted judicial release effective today, which I believe that's what the defense's hope is. As I've already indicated, the state, and the reasons for the opposition are outlined in the memorandum that was filed on November 1st. The state has also consulted with the victim in this case, Mr. Page, who's indicated he is also opposed to judicial release at this time. It was Ms. Baker who really started the chain of events that unfolded on this particular evening when she fired a shotgun at Mr. Page as he was driving down the roadway. As the court's already indicated, this defendant was granted an appellate bond. Her conviction was affirmed by the Court of Appeals, and then she began serving her sentence in April of this year. At this point, the state feels that judicial release would be premature. However, the state would have no opposition to judicial release effective, approximately 6 months from now. So that's all I have, Your Honor. Thank you.
Ms. Baker, is there anything you would like to say?
Yes, Your Honor. I would like to say that I have made a terrible mistake, and I deeply regret my actions of that night, and I wish that it had never happened. I thank God every day that nothing happened to Wade or myself. I was 60 years old at the time, and I had never been in trouble in my entire life. I am now 62, and 2 years later, it is still the only trouble I have ever been in. After this happened, I was on house arrest for 13 months with no problems. I have complied with everything this court has asked of me, and my fines are paid. I've been in prison for 8 months, and there has been no trouble. I've worked in food services since I was transferred here from Marysville. I am an honest person. I called the sheriff that night and let them know what had happened, because it was the right thing to do. My actions was from the constant fear that my daughter and I lived through that summer. Every day I wondered, would this be the day that I would find my daughter dead? I've learned my lesson though. A person, my daughter, must want to help herself or I cannot help her. I had moved her off of my property 2 years ago and there's been no problem since. I made a mistake and it will never happen again. I have always been honest, hardworking, and responsible. And even though I lost a good job of 22 years, I had figured things out. I had started receiving widow's benefits, which was more than enough to pay my bills. However, those benefits have been suspended till I am released, and there is no money coming into my household. I was also working for the Amish to make extra money. Your Honor, I am also very worried about my farm and my home. The Keers that have been taking care of it have done an excellent job for the past 8 months, but I cannot expect them to keep it up. They have their own businesses and families to attend to, and now it is winter, and it will become increasingly hard for them to travel across the county to take care of my farm. If I am not released and they cannot take care of my farm, my cattle will have to be sold. The cattle is what pays for the farm, and without them, I will most likely have to sell the farm and my home. As I stated in my letter to you, I am very worried about my health. I am a type 1 diabetic that has been on an insulin pump for 20 years. For the past 8 months, I have had to take shots. Shots do not control my diabetes. Plus, for 6 months of this, I was under a policy that where if my sugar was below 90, they did not give you any insulin. That includes the MPH, or the long-acting, that controls my sugar through the night. The next morning, my sugar would be above 500, my heart would be pounding out of my chest, and it felt like I had cement blocks attached to my legs and my arms. I do not know of any endocrinologist that would condone withholding insulin from a diabetic. However, around October the 21st, the new healthcare administrator worked around this policy, and we now receive glucose to get our shots. But shots still do not control my diabetes. I have dawn phenomenon where my sugar rises around 4 a.m. in the morning. Shots do not address this. The insulin pump can be set up so it increases your insulin intake around 4 a.m. to control the dawn phenomenon. And I just pray that the past 8 months has not done any damage to my organs. I am 62 years old. I am not young anymore, and I do not heal the way I used to. Since I've been at DCI, I've had to make 4 trips a day to the infirmary to get my insulin. That is over 800 trips and over 400 miles that I have walked to get insulin. Plus, I've worked in food service where I'm on my feet. All this has severely affected my knee, which is staying swollen, and I'm having stabbing pains in it now. It needs rest to heal, but I cannot get that within the trips that I have to make for insulin. Your Honor, I made a mistake. I promise it will never happen again. It has been 2 years since this happened, and at 62, it is the only trouble I have ever been in my life. I am very worried about losing my farm, and my widow's benefits will not resume until I'm released, so there is no money in the house coming into the household. I have had the money to cover, but that won't last without income. I just want to put this behind me and move on with my life. Prison has been a very harsh punishment on me, especially physically. But my greatest punishment of all is my granddaughter, which I have raised since she was 15, will graduate college this Saturday, and it breaks my heart that I will not be there to support her and cheer her on. Your Honor, I would ask that for my health and future that you would grant judicial release. Thank you.
Anything else, Mr. Bolger?
Yeah, there's one comment, It's quite likely that this matter that happened in that early morning hour would never have come to the attention of law enforcement had Ms. Baker not called the Sheriff's Department after firing her weapon and immediately notifying them of the event. We know that Mr. Wade Page was not inclined to contact law enforcement. He fled from them, damaging a police cruiser and disabling it in a state of high intoxication. So there are significant reasons to distinguish between the treatment that these two people are being given, I believe.
Right, thank you. Well, you know, it was a difficult case. Ms. Baker, obviously, you're right, Mr. Bolger, wouldn't have been, most likely would not have been reported had she not made the report. But the whole thing was said in his conduct, you know, I'll say that I agree with this defense contention. I think Mr. Page's conduct was probably worse than hers. He did return back. He was drunk, though. Returned back to fire shots at her, and then you know, ended up confronting law enforcement, and that whole thing occurred. But none of that would have occurred without her committing the offense either. The court feels that judicial release is appropriate, but that there needs to be a little bit more time. I agree with the state that, again, although I think Mr. Page's conduct was probably worse, again, none of that would have occurred without her actions. And so I'm granting you judicial release, Ms. Baker. I'm going to make it effective on February the 18th. I believe that is a Tuesday. That will make approximately 10 months that you serve. I had a conversation prior to the hearing with the council, and I had indicated April, but I was thinking the reception date was in July, but it was in April. So I've adjusted my dates accordingly. That may be slightly less than Mr. Page or slightly more, I don't know. But I think the 17th is a holiday, and so it'll be effective on the 18th. You will be required to report to the probation department in person on the next day, February the 19th. Now, your conditions of supervision, Ms. Baker, will be, you'll be supervised for up to 3 years, or for a period of 3 years. Could be less if the probation department recommends and the court approves, but for now, this term is 3 years. You'll be required to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed. Must be truthful in all statements you make to the probation department. You must report when and as directed, keep them informed of your residence, place, employment at all times. You may not change either of those without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you do, you must have that pass on your person when you're in the other state. You may not enter upon the grounds of any correctional facility or communicate or attempt to communicate with anyone as an inmate in any facility of any jurisdiction without prior written permission. You're prohibited from purchasing, possessing, owning, using, and having under your control any kind of firearm, ammunition, or dangerous ordnance. And also, because of your conviction, that would be a felony violation under both federal and state law for you to do that unless you have that disability removed in the future. Also, you're prohibited from having those items in this case or any other weapons. You may not purchase, possess, use, have under control an alcoholic beverage or any controlled substance, drug abuse, or instrument, device, or thing. May be used to administer those unless you have a lawful prescription for both the substance and the device, and provide a copy of that within 24 hours to your supervising officer. You may not associate with anyone who has a criminal record, a member of a gang or the criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions. That applies to family members that may fall within that definition. Unless you're living with them immediately before the commission of this offense, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. Must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer a financial information record so your ability to pay any fines or costs can be reviewed. I don't think there was any restitution ordered because it was not calculated. Is that correct?
Can you verify that, Your Honor?
Yeah, it was not ordered, if I recall. If you're referred by probation to be evaluated or assessed for any other type of programming, counseling, treatment, etc., you're to enroll in and, or you submit to that, and if there's a recommendation for programming, then you're to enroll in and successfully complete that. And you're to pay the court cost, make payment arrangements to do that with the clerk. And if you fail to pay the court cost, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then they could be referred to collections, and then that would result in an additional 30% being required to be paid on top of the original court cost order. Now, by being placed on community control rather than being and released from prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property or place that's under your control or where you're found at any time by any officer of the probation department. You'll sign a written acknowledgement and consent for that for the probation department when you report. Now, in the event that you're found to have violated any of these conditions, that could only occur after a hearing in which you were given written notice of the allegations, and you would have a hearing in which you would have the right to have counsel. In the event it's proven that that's occurred, your community control will be revoked. You'll be required to serve the balance of the sentence, and if you should be revoked in part because of or whole because of a new felony conviction and are sentenced to a term of incarceration on that offense, then the two terms could be ordered to be served consecutively to each other. All right, so the court will notify the institution, and like I said, you'll be able to be released on the 18th, and then report to probation the next day. You have any questions, Ms. Baker?
No, Your Honor.
All right, Mr. Bolger, anything?
No, Your Honor.
Mr. King?
No, Your Honor.
All right, thank you. This is case number 22 CR 200, State of Ohio versus Jason Wright. Mr. Wright's appearing by Zoom from the jail. His attorney is Jacob Wagner. He is in court here. He was not able to connect to the Zoom call, so he's present in the courtroom. And then representing the state from her office is Prosecuting Attorney Collins. And Mr. Wagner, are you all right with your client appearing by Zoom rather than in person in the courtroom?
I am, sir. We spoke about this morning.
And you're all right with that, Mr. Wright?
Yes, sir.
All right. In the event you need to talk to him, let me know, and I can put my computer on mute, step out, let him talk to you.
I just got the link.
Okay, he said he just got the link, so he'll be signing in here shortly. All right. Let me see here. Mr. Wright was placed on community control. Here, I got to admit Mr. Arjima too. Okay. Mr. Wright was placed on community control on January the 6th, 2023 on a charge of aggravated possession of methamphetamine, a third-degree felony. The court received a notification of alleged violations from the probation department on 12/2 that alleged that Mr. Wright has violated Rule 2, failed to make contact since August of 2024, and Rule 7 that on 12/2 he was given a drug screen at the jail and tested positive for marijuana. The court notified Mr. Wright of the alleged violation and appointed Mr. Wagner to represent him and set the matter for hearing today. Now, Mr. Wagner, have you had an opportunity to review the allegations and consult with Mr. Wright?
We have, sir. We did this morning, and he does admit to the violation, sir, waive a formal hearing.
Okay. Were you able to hear that?
No, sir, I didn't hear it.
All right, wait a minute. I thought I had you admitted, but now you're admitted. Okay. All right. I thought I had pressed the button to admit him, but I hadn't. So, Mr. Wagner, have you had an opportunity to consult with your client?
I have, Your Honor. We went over the violations as far as the testing positive and non-reporting. He does admit to those violations, sir.
All right. So, Mr. Wright, you do have a right to have a hearing on these allegations, which the state would have to prove to the court's satisfaction that you have violated these conditions through testimony. You have a right to have your attorney cross-examine those witnesses and present evidence and testimony on your behalf, although you're not required to. In the event that you are found to have violated these conditions, I can do one of three things. I can continue under the same conditions previously ordered. I could continue you on community control with additional conditions that I think are appropriate. Or the third and the most serious is I could revoke your community control and sentence you to prison for a period of between 9 and 36 months and fine you $10,000. Do you understand that?
Yes, sir.
You understand your right to a hearing?
Yes, sir.
Has anyone threatened you in any way or promised you anything to get you to admit to these violations?
No, sir.
All right. Then do you admit to the violations that were filed against you, were you notified about?
Yes, sir.
All right. All right. Ms. Collins, anything from the state or the probation department regarding Mr. Wright's disposition?
Yes, the probation department is recommending that Mr. Wright be continued on community control, but that be extended by 1 year, that he be ordered to enter and successfully complete the STAR program.
Enter into what?
Enter and successfully complete the STAR program.
Okay. All right. Mr. Arjima, has he been assessed for that?
Yes, Your Honor, he has a bed December 31st.
All right. Mr. Wagner?
Your Honor, obviously we're in agreement with extending the community control. When I met with my client this morning, he was unaware that he'd been assessed for the STAR program. What we would request, I don't know if the court would be inclined or not, is he's at the Recovery Council right now, Your Honor. He's been there, I don't know, for a year. I'm not sure exactly how long. He did have a letter. I've not read it yet, though. But that's where he's at. We would ask that he just be continued at the Recovery Council with an extension of his community control, Your Honor.
Looks to me like he's in jail.
He was, but his treatment has been at the recovery council.
Was that in residential or in outpatient?
He was outpatient.
All right. Mr. Wright, anything you'd like to say?
Yes, sir. I was at the Recovery Council outpatient, and I was issued a new counselor because my counselor there was moving to a different division, which wasn't the Recovery Council. But I was assigned a new counselor there at the Recovery Council outpatient.
Okay.
I have a letter stating it.
All right. All right, anything else?
No, sir.
All right. Well, the court is going to go ahead and continue on community control under 3 additional conditions, in addition to the original conditions, which are still in effect. Your community control is going to be extended by 1 year. I'm going to order you complete the STAR program. Going through the outpatient seems not to be effective since you did test positive and you weren't reporting, and that would indicate to the court in most cases when people stop reporting is because they're going to be dirty or they're on the run for something else, and that's not the case here. So the only thing I can conclude is you quit going because you didn't want to test positive. And so we're going to require that you complete the STAR program. The bed available for you on the 31st of the month, so you remain in jail until that time. You're also to complete any aftercare that they recommend. All right. Anything further from counsel on this case? All right. Thank you. All right. We need Mr. Jemison next, please. All right, are you Joseph Lawrence Jemison appearing there from the jail?
Yes, sir.
All right, this is case number 23CR229, State of Ohio versus Joseph Lawrence Jemison. This is a Zoom hearing. Mr. Jemison's appearing from the jail. His attorney is Jacob Wagner, appearing by Zoom on his phone and appearing from the prosecutor's office, Prosecutor Collins. The defendant was indicted back in December of last year on assault on a peace officer and 2 counts of failure to comply. He was found not competent to stand trial, but that there was likely he would be able to be restored within the time provided by law, and so he was sent for treatment, and the court did receive a report back from the treating facility indicating that he had been restored to competency. That report was received by the court December the 4th. Have each of the attorneys had an opportunity to review summary? Actually review the report?
I have, Your Honor.
All right. Does either counsel wish to present any additional testimony on the matter?
No.
Testimony or evidence, I guess no evidence, Your Honor. I guess only that. I've never done this in 23 years, but while I respect the report's opinion, I disagree with it. I think to restore someone to competency assumes that they were competent at one time. My client has a long history of mental health. He was to be probated days prior to this incident occurring. I'll move forward accordingly, but I disagree with the report, Your Honor.
Okay. Well, in the absence of any other evidence, the court will accept that report and will find that he is capable of understanding the nature of proceedings of the case and the ability to assist with his defense. We will set the matter for a first pretrial on January the 8th at 1 o'clock. Second or final pretrial will be January the I don't think we've had any pretrials in this, have we?
Maybe a first one real early.
No, because he went right into, you filed immediately, I think, for a review or an evaluation. Final pretrial then would be January the 22nd at 1 p.m. And then we'll set the trial date for February the 10th at 8 a.m. Ms. Collins, I forgot to ask, have the alleged victims of the offense has been notified of the time, place, and purpose of the hearing, the right to be heard?
They have, Your Honor, and elected not to appear.
All right. All right. Anything further from counsel then?
Bond, Your Honor?
Bond will be continued as the same amount previously ordered, unless there's a, I don't remember what that was. Look and see here.
$50,000.
Yeah, 50,000. And I don't think there's been any, previous posting of the bond, but even if there had, it would have to be renewed if the company was in favor of it. So bond will be continued. Yeah. All right. Thank you.
Thank you, Your Honor.
Yeah. All right, this is case number 22 CR 207, Dylan, State of Ohio versus Dylan T. Schumacher. Present on behalf of the state is Prosecutor Collins. Present on behalf of the defendant is Dennis Kirk. And you're Dennis Schumacher appearing there from the jail?
Yes, sir.
Okay. This is set for a pretrial, and I have been presented with a plea of guilty form. Mr. Kirk, is it okay with you and your client, this matter be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, Your Honor.
All right. And that's all right with you, Mr. Schumacher?
Yes, sir.
All right, if at any time during this proceeding if you need to speak with him or ask him a question, just let me know, and I'll put you into a breakout room where it'll be just the two of you on the screen. No one else will be able to see you or hear you, and the officer will step out while you're talking. All right. Mr. Schumacher is indicted on 2 counts of trespass and a habitation when a person is present or likely to be present. Ms. Collins has the alleged victim of the offenses, victim or victims of the offenses been notified of the time, place, and purpose of this hearing, the right to be heard?
They have, Your Honor, and have elected not to appear for the hearings, advised they would not be here.
Okay. All right. Mr. Schumacher, I've been presented with a plea of guilty form here that indicates you're going to withdraw your plea to count 1 and plead guilty to count 1, and I'm going to hold up this plea agreement, the first page. It has your name, case number, and says plea of guilty, and then count 1 right below that. Can you see that document there I'm holding?
Yes, sir.
You recognize it?
Yes, sir.
All right, on page 3, there's a sentence. The last sentence reads, "I enter this plea voluntarily." Below that appears to be signature Dylan Schumacher, and I'll hold that up to the calendar. And is that your signature?
Yes, sir.
And when did you sign this document?
Yesterday.
All right, and when you signed it, did you understand it was agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
And did you enter into this agreement voluntarily?
Yes, sir.
And are you going forward today voluntarily?
Yes, sir.
All right, now the agreements, or the document states on page 1 you're going to plead guilty to count 1, and that you understand that there could be a penalty imposed of between 6 and 18 months of prison and a fine of $5,000 and a license suspension of 6 months to 5 years. Oh, no, that's not right. There's no license suspension on this, Ms. Collins, is there? It's on the form. I assume that's just a cut and paste error.
There should not be.
Yeah, okay. I've stricken that out. So it's 6 to 18 months and $5,000. You understand that?
Yes, sir.
All right. Are you currently facing any felony charges anywhere else?
No, sir.
Are you under community control, probation, parole, or post-release control for a felony?
No, sir.
All right. Now, under the law, if you are convicted of this offense and if you should serve a prison term, it is possible that the Adult Parole Authority would put you under post-release control for a period of up to 2 years, which means you'll be supervised by a parole officer under terms they set. And if during that period of time they determine that you have failed to comply, they can return you to prison, make you serve an additional period of up to 9 months for any one violation, which is also half is a cap, so that would be the most for multiple violations if you got the maximum. But if you got less than the maximum, it would be half of whatever that term was. However, if you're convicted of a new felony, under post-release control, then in addition, whatever sentence the judge in that case can impose, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense. I can place you under what's called community control or probation. And that means instead of going to prison, you'd be put under the supervision probation officer for a period of up to 5 years. And if during that period of time probation felt that you were not compliant, they would file a written notice of that with the court. There would be a copy given to you. There would be a hearing, and if the outcome of which you could have an attorney, if the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to the term of 6 to 18 months and fine you $5,000. And if your revocation of community control is due in part or whole to a new felony conviction and you received a sentence in that case, the sentences could be ordered to be served consecutively to one another. Do you understand that?
Yes, sir.
Right now, the charge in this case alleges that on or about September 16, 2022, in Highland County, Ohio, you did by force, stealth, or deception knowingly trespass in the residence of 214 Cedarwood Drive, apartment 17, Hillsborough, permanent or temporary habitation of any person when a person other than an accomplice of the offender is present or likely to be present in violation of section 2911.12B of the Ohio Revised Code. So that is the charge with the penalties I just described. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there are a couple of lines that are printed in bold and underlined that read as follows. Defendant will enter plea of guilty to count 1. State will dismiss count 2. State defense jointly recommend community control and a referral to drug court. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter sentences up to the judge, not the parties. And so even though there's been an agreement between the two parties that you should get community control, that's not binding on the court. So if you do plead guilty, once I've heard all the information that's submitted, if I decide that's not the correct sentence, I could impose a sentence of between 6 and 18 months and fine you $5,000. You understand that?
Yes, sir.
All right, now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept a plea from you. First of all, you have a right to have counsel, and Mr. Kirk was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So if you decide you don't want to do this, that you'd rather defend against the charge, he will continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are residing in Highland County that are called into jury duty on your trial date. After they are selected, the evidence will be presented. Hold on here a second. Mr. Wagner, I was just seeing here that Ms. Eubanks isn't scheduled till 2:15. Did you get a hold of her to get her to come in early?
I apologize, sir. Yeah, I've been texting her and talked to her all day. I was getting ready to check on her and tell her to hustle down there.
Yeah, okay, go ahead and do that, because I'll do her right next if you can get her here. Otherwise,
Thank
we're
you,
going to
sir.
have to make her come back a different day.
I apologize, sir. I'll just.
That's
we'll
not
get
your
there,
fault,
sir.
yeah. All right, thank you.
Thank you.
All right. All right, so going back then, just to make sure I covered it, you do have a right to have a jury trial. 12 people that live in Highland County would be selected from a group of Highland County residents or summons for jury duty. They'd be hear all the evidence, and then they'd be instructed on the law by the judge, and that jury of 12 would then decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. You didn't want to have a jury trial, but you didn't want to plead guilty. You can waive in writing, which means to give up the right to have a jury trial. In that case, you would have a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. You understand that?
Yes.
Now, under the Constitution, you have a right to confront the witnesses against you in open court, cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Now, under the Constitution and the law, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, And that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, sir.
Under the Constitution, you are entitled to a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one is ever allowed to make you testify. The judge can't, the prosecutor can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Now, under the Constitution and the laws of this state, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So, what that means is that the burden of proof isn't on you to try to show that you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any offense, and it exercised or invoked all the rights I just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime. And that plea waives or gives up all the rights that I've described for you today, except your right to have counsel. You always have a right to have counsel no matter what your plea. But if you plead guilty, then you waive or give up your right to a jury or court trial. You waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. You waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. You waive or give up your privilege against self-incrimination, because if you say you're guilty, the state has to prove you're guilty. And it waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. And if you plead guilty, you're waiving your privilege against self-incrimination, so that's what's used to find you guilty. Subjects you to being sentenced immediately by the court. And finally, it waives, gives up your right to file an appeal on any alleged violations of your rights you feel may have occurred up until this point in the case. Now, if I should sentence you to the maximum sentence or under other limited circumstances, an appeal can be filed. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalties?
No, sir.
You understand them?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
And you understand it?
Yes, sir.
You understand that the recommendation on sentencing is not binding on the court?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea?
No, sir.
You understand?
Yes, sir.
Yeah. Anything you need to speak to Mr. Kirk about before we go any further?
Maybe for just a second, if it's all right.
Yes. All right, there's going to be a button that's going to open up, say join breakout room. Click on that, and then when you're done, you'll click on leave it, and the deputy will come back in, and you'll have to re-click to join the session again.
All right.
Miss Eubanks there yet, Miss Benson?
No, sir, she's not here yet.
All right, Mr. Wagner, we'll go ahead and just continue this to a different time, and when she comes
Your Honor, I
in.
can hang on for a little bit. I've got.
Oh, I thought you had to be gone by
Hospital.
1:15 or 1:20.
No, sir, if I'm gone by 2, I should be fine.
Oh, okay, all right, well, as soon as she gets here, we'll do her this then.
I appreciate it, sir. Thank you.
Okay. It went from the lower right-hand corner to the middle. All right. All right, so we're back, and are we ready to go forward then, Mr. Kirk?
We are, Your Honor.
All right. Then, are you a U.S. citizen, Mr. Schumacher? I forgot if I asked you that or not. Okay. Then it's your decision to go forward and plead guilty to the charge?
Yes, sir.
Count one, all right. Then as to the charge of count one, which alleges that on or about September 16, 2022, in Highland County, Ohio, you did by force, stealth, or deception knowingly trespass in the residence at 214 Cedar Woods Drive, apartment 17, Hillsborough, the permanent temporary habitation of any person when a person other than an accomplice of the offender is present or likely to be present, violation of section 2911.12B of the Ohio Revised Code. The charge of trespass in a habitation when a person is present or likely to be present in violation of section 2911.12B of the Ohio Revised Code, fourth degree felony, carrying possible prison term between 6 to 18 months and a fine of $5,000. How do you plead?
Guilty.
All right, the court finds that on this day in open court, the defendant was advised of all the constitutional rights and made a no intelligent voluntary waiver of the same pursuant to criminal 11. The pleas accepted, order filed. Defendant is found guilty of this offense as charged. The case is referred to the probation department for a pre-sentence report, including an assessment for substance use disorder and mental health issues. And sentencing will be January 23rd at 1 o'clock. Bond will be continued. Ms. Collins, for purposes of drug court, this is not considered an offense of violence, is it? You're muted.
I don't believe so. Mr. King and I were just talking about it. We don't believe so.
Yeah, I don't think it is either, but we'll need to check that to confirm because that could have bearing on his eligibility. So I'm going to go for drug court, but I'm going to go ahead and refer the case to the drug court for now, and then we can address that issue if needed. All right, thank you. All right, the next up then would be Brian Ocran. All right. Case number 22 CR 240, State of Ohio versus Brian Theodore Ocran. Are you Brian Theodore Ocran appearing there from the jail?
Yes.
All right. This is a hearing being conducted by Zoom, scheduled as a pretrial. Mr. Ocran's attorney is Catherine Hatner, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. And the defendant is charged with illegal conveyance and possession of drugs as a pretrial, as I said. And I have been presented a plea of guilty form. Ms. Hapner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance?
Yes, we are.
And is that all right with you, Mr. Ocran?
Yes.
All right. Since you're not seated next to your attorney, if you do need to talk with her about anything or ask her any questions during the hearing, just tell me, and I can put you and her into a breakout room. It'll be just the two of you on that screen. No one else will be able to see you or hear you. And while you're consulting with your attorney, the deputy will step outside of the room, okay?
Okay.
All right. Now, Mr. Ocran, I have this plea of guilty form, and I'm going to hold this up to the camera. The first page has your name and case number. It says plea of guilty, count one. So I'm going to hold that up to the camera. And do you recognize that document?
Yes.
And on page 3, the last sentence reads, I enter this plea voluntarily. Immediately below that, there's a signature line that appears to be Brian Ocran to me. I'll hold that up. Camera, is that your signature?
Yes.
When did you sign this document?
2 days, I believe Friday.
All right. And before you signed it, did you talk to your attorney about it and have her answer questions and explain everything to you?
Yes.
Need to answer.
Yes.
Okay. And You knew it was an agreement to plead guilty, meaning there's not going to be a trial, and the next step in the case would be a sentencing hearing.
Yes.
And do you think you had enough time to fully consider the matter before you signed the document?
Yes.
And since it's been a few days, have you had any change of mind, or is this still what you want to do?
Yes. Still what I want to do.
All right. And you're doing this voluntarily?
Yes.
All right, now the agreement states on page 1, you're going to plead guilty to count 1, which is illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility in violation of section 2921.36A2, a third-degree felony. It states you understand that could be punished by a term of imprisonment of between 9 and 36 months and a fine of $10,000. You understand that?
Yes.
Are you facing any felony charges anywhere else?
No.
Are you currently on community control, probation, parole, or post-release control for a felony?
No. I have a Pickaway County child support, but I'm not sure what that is.
Okay. You don't know if it's a criminal or a civil case?
No.
Okay.
They just told me whenever I got here.
All right. Well, for whatever it's worth, if it's a criminal case, that's not going to affect anything as far as I'm concerned. But the prosecutor, you're aware of that, Ms. Collins?
I believe it's just a contempt.
Yeah, it sounds like it might be. Yeah, okay. Well, we'll go on then. Now, Mr. O'Cran, if you should be convicted and sentenced to imprisonment on this charge at any time, once you complete the prison term, the court orders, the law provides that the Adult Parole Authority may, at their option, put you under post-release control supervision for up to 2 years. If they do, you'll be supervised by a parole officer, the terms they set, and if during that period of time that you're under supervision, you violate a condition, then they have the power to punish you or sanction you for that by making you go back to prison to serve an additional period of up to 9 months for any one violation, but there is a cap or limit of half of whatever your prison term was for more than one violation, one or more violations. However, if you are convicted of a new felony while under post-release control, then in addition, whatever sentence a judge in the new case could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation. That means you'd be supervised for up to 5 years by a probation officer under terms set by this court. If during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court and give you a copy. There would be a hearing at which you would be entitled to have an attorney. And if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for the 9 to 36 months, fine you $10,000. And if the revocation was due in part or whole to a new felony conviction and you were sentenced to prison on that, that sentence could be served consecutively to the sentences in the sentence in this case. Do you understand that?
Yes.
All right. Now the charge in count 1, Mr. O'Cran, indicates. By the way, am I getting that correct? O'Cran and not O'Cran? Yes. All right, O'Cran. I thought with it sounds a little Irish. I don't know, but anyway. The charge is in honor about May 19, 2022 in Highland County, Ohio, that you and Brandy Ray Curtis did knowingly convey or attempt to convey onto the grounds of a detention facility, Greenfield Jail, a drug of abuse as defined in ORC 3719.011, to wit, buprenorphine and gabapentin in violation of section 2921.36A2. So that's the charge with the penalties I described earlier. Do you understand what it is you've been charged with, what the state said you did, when, where, and how they led you did it?
Yes.
And you understand the possible penalties if you're convicted?
Yes.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice, or her advice, and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, on page 2, There are several lines that are printed in bold and underlined, and then part of the last sentence is stricken out, so it doesn't apply. So I'll read what does apply, as I understand it. If I'm wrong, counsel can correct me. Well, I believe what the agreement is that defendant shall enter a plea of guilty to count 1. State will dismiss count 2. State and defense jointly recommend community control and a referral to drug court. Is that your understanding of the agreement?
Yes.
And does anyone promise you anything other than that to get you to plead guilty here today?
No.
Now, under the law, Mr. O'Cran, the matter of sentence is up to the judge, not the parties. So if you plead guilty, I'm not required to follow the recommendation that you get community control and drug court. In fact, if you plead guilty, and once I've reviewed everything, if I think that's not the right sentence under the facts and the law, you could be sentenced to any term between 9 and 36 months, fine $10,000. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that occupies any, that regulates, I should say, any trade or profession in the state of Ohio?
No.
All right, now you have constitutional rights, you must understand, before I can accept your plea. First of all, you have a right to have counsel, and I appointed Ms. Hapner to represent you. That appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like her to provide. So if you decide you don't want to do this, she'll continue to represent you. You'll have counsel to defend you at trial, if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, those 12, the evidence will be presented, they'd be instructed on law by the judge, and then they would decide by a unanimous verdict, meaning all 12 have to agree, on whether the state proves your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up, the right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning the judge would be the one, instead of a jury, that would listen to the evidence, apply the law, and decide whether or not to that the state proved your guilt. Do you understand that?
Yes.
Now, you have a right under the Constitution and the law of the state to confront the witnesses against you in open court and to cross-examine them through your attorney. That means the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. You understand that?
Yes.
Under the Constitution, you have the right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes.
Under the Constitution and the laws of the state, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof is not on you to try to prove you're not guilty. The burden of proof is upon the state to prove you are guilty. In fact, at trial, you don't have to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt or prove beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes.
And see, did I explain the right of self-incrimination? Or did I skip over? I did.
Yes, you,
Okay. I was looking at something else and multitasking, and I couldn't remember. I checked it, but I want to make sure. All right. So you understand your right about privilege against self-incrimination. Okay. Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed a crime. And that plea waived or invoked all of the rights that I've just described. If you change your plea from not guilty to guilty, that is a complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment in count 1, admits that it's a crime, that you committed that crime. And that plea would waive or give up all of the rights that I have explained for you, except your right to have counsel. You always have a right to have counsel no matter what your plea. But Otherwise, a plea of guilty would waive or give up your right to a jury or court trial, waives or gives up your right to confront witnesses against you and to cross-examine them through your attorney, waives or gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It waives or gives up your privilege against self-incrimination because you're saying you're guilty, so that's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you could have had up until this point in the case. Now, if I do sentence you to the maximum sentence, you can appeal that, or under other limited circumstances, an appeal could be filed. The deadline to file such appeal would be 30 days after the filing of your sentencing entry. Do you understand all of that? And are you a U.S. citizen, Mr. Okran?
Yes.
All right, now, do you have any questions about the charge and the possible penalties?
Go ahead and answer out loud.
I see your head, but I need to hear it verbally, okay?
No.
Okay, because if somebody were to transcribe this, they are not going to see the video, they're going to listen to the audio, so. Okay. Do you have any, so you do understand him?
Yes.
Any questions about the plea agreement?
No.
You understand it?
Yes.
And you understand that the court's not bound by the sentencing recommendation?
Yes.
You have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand?
Yes.
All right. Is there anything you'd like to speak with your attorney about before we go any further?
No.
You have any questions at all?
No.
Then is it your decision to go forward and plead guilty to count 1 pursuant to the terms of the plea agreement that we have just gone over?
Yes.
All right. Then as to the charge, which alleges that on, and this is just the pertinent part, on or about May 19, 2022 in Highland County, Ohio, that you and Brandy Ray Curtis did knowingly convey or attempt to convey onto the grounds of a detention facility, Greenfield Jail, a drug of abuse is defined in ORC 3719.011 to wit buprenorphine and gabapentin, violation of section 2921.36A2, the defense of illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, a third-degree felony, carrying possible prison term between 9 and 36 months, a fine of $10,000. How do you plead? How do you plead?
Guilty.
All right. The court finds then on this day in open court, the defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver of the same. Pursuant to Criminal Rule 11, pleas accepted in order to file. Defendants found guilty of count 1, count 2 is dismissed. Court will refer the matter to the probation department for a pre-sentence report, which shall include an assessment for substance use disorder and/or mental health issues. The case is also referred to the drug court, and the hearing will be set on sentencing on January 23, 2025 at 1 p.m. Bond will be continued.
Your Honor, I'm going to be out that day.
Oh, okay.
I'll be back the following week.
Okay. Let's make it February 5 then at 9 a.m. Are you available then?
That works.
Okay.
Your Honor, I've also been informed by Mrs. Sturgill that she will have a bed available for him next week. So we would ask for you to consider an OR bond when that bed becomes available.
Okay, well, if that becomes available, file a motion and the court will entertain that.
Okay. Thank you.
All right, thank you. All right, Mr. Stone next, please. All right, are you Billy J. Stone?
Yes.
Joe Stone, I guess it is, all right. Case number 24-CR-125, State of Ohio versus Billy Joe Stone. Present on behalf of the state. This hearing is being conducted by Zoom, by the way, so Ms. Collins is a prosecutor appearing on behalf of the state from her office. Defense represented by Catherine Hapner, appearing from her office. Mr. Stone is appearing by Zoom from the jail. He is charged with aggravated possession of methamphetamine, a third-degree felony. The matter is set for trial. Let's see. Find that. Looks like January 13th at 8 a.m. And this is a final pretrial. All right, now discovery complete from both sides.
It is from the state.
Ms. Hapner?
Your Honor, it's actually my case.
I'm sorry, Mr. Kirk. I'm sorry.
Yes.
I skipped over your case, and I had 4 in a row for her, and I just was operating off that list. Go ahead.
It is complete. He was furloughed for some medical and is now back at the jail, so I believe there's a possibility of a resolution yet. So I am going to go out and see him tomorrow and try to get an update from him.
Okay. All right. Well, we might explain to Mr. Stone that there's a 2-week deadline, so you're not scheduled for trial the 13th, but that means it's going to have to be before, on or before December 31st. So I don't remember. Yeah, that's New Year's Eve. I mean, we will be working, so we'll be available if somebody needs to be here. So, all right. Anything further from counsel?
No, Your Honor.
All right. Thank you. All right. Christopher Brigner, please. All right, this is case number 24, CR158, State of Ohio versus Christopher A. Brigner. Are you Christopher A. Brigner appearing there from the jail?
Yes, sir.
All right, this is a hearing being conducted by Zoom, scheduled for a pretrial. Mr. Brigner's attorney is Catherine Hapner, appearing from her office. Appearing on behalf of the state is Prosecutor Collins. Now, this, as I said, is set for a pretrial, but I have been provided with a proposed plea of guilty form. So, Ms. Hapner, are you and your client both in agreement that matter can be, this hearing can be conducted by Zoom rather than
Yes,
an
we are.
in-person appearance? Okay. And that's all right with you, Mr. Brigner?
Yes.
All right. If during this hearing you need to talk to Ms. Hapner, you just tell me. I'll put the two of you into a breakout room, meaning this will be the two of you on the screen, and no one else will be able to see you or hear you, and the deputy will step out of the room during your consultation, okay?
Okay.
All right, now, Mr. Brigner is charged with, along with the co-defendant, with aggravated trafficking and possession of methamphetamine, and the matter is set for trial, it looks like, on January the 16th. Now, I've been presented with a plea of guilty form, and I'm going to hold the first page up to the camera, which has your case name and number and a plea of guilty, and it says count 1, and ask you if you recognize that document there.
Yes.
On page 3, the last sentence reads, I enter this plea voluntarily, and immediately below that there appears to be a signature, Chris Brigner, and I'll ask and hold that up and ask you if that is your signature there.
Yes.
When did you sign this, Mr. Brigner?
It was last Friday.
Yeah.
Monday, all right. Now, before you signed it, Mr. Brigner, did Ms. Hapner go over it with you and explain things to you and answer any questions that you had?
Yes, sir.
And you feel you had enough time to fully consider the matter before making the decision?
Yes, sir.
And since it's been a couple of days past, have you had any change of heart? Is this still what you want to do?
Yeah, it's still with, yeah.
All right, and you're going forward voluntarily?
Yes.
All right. Now, the document states on page 1, you're going to plead guilty to count 1, aggravated trafficking of methamphetamine under 2925.03A1, fourth degree felony. Further states you understand that the penalty for that could be 6 to 18 months in prison, a $5,000 fine, and a license suspension of 6 months to 5 years. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Now, under the law, if you should be convicted of this offense and sentenced to prison, upon completion of that prison term, the law provides that the Adult Parole Authority may, at their option, put you under post-release control for a period of up to 2 years. And if they do, you'd be supervised under the terms they set by a parole officer. And if during that period of time they found that you had failed to comply, they could return you to prison to make you serve an additional period as a sanction of up to 9 months for a single violation. But there is a cap, and so in this case, the cap for you would be half of whatever prison term was imposed for one or more violations.
Yes.
However, if you're convicted of a new felony, then in addition, whatever sentence could be imposed by the judge in the new felony case, that judge could also sentence you, if you committed that offense while under post-release control in this case, to an additional period of 1 year, or whatever time is left on that post-release control period, whichever is greater. And if that occurs, that has to be served consecutively, the sentence in the new case. Do you understand that?
Yes.
Now, I'm not required to sentence you to prison for this offense. I can't impose community control or probation. What that means is instead of going to prison, you would be put under the supervision of a probation officer under terms set by the court for a period of up to 5 years. If during that period of time the probation department thought that you were not compliant, they would file a written notice up with the court and give you a copy. There would be a hearing. You'd have a right to have an attorney represent you at that hearing. And if the outcome of the hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to a period of 6 to 18 months and fine you the $5,000. You understand that?
Yes.
All right. Now, and also, if you were revoked because you were convicted of a new offense and received a prison term for that, the sentences for that offense and this offense could be ordered to be served consecutively to each other. You understand that?
Yeah, I'm aware of that. Yeah.
Okay. All right, now, charge in count 1 reads that on or about June 17, 2024 in Highland County, Ohio, that you and Alan R. Green did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1 of the Higher Revised Code. So that's the charge of the penalty I've just described. Mr. Brigner, do you understand what it is you're charged with, what the state said you did, when, where, and how they led you did it?
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty?
No, sir.
Now, on page 2, there are several lines that are printed in bold and underlined. Part of them have been stricken out, so I'm going to read the part that, as I understand, is the plea agreement, and if counsel disagree, they can correct me. And it reads that defendant shall enter a plea of guilty to count 1, state will dismiss count 2, state and defense jointly recommend community control in drug court, defendant shall repay buy money of $30 and cooperate fully with the task force. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, Mr. Brigner, the matter of the sentence is up to the judge, not the parties. And so even though there's an agreement by the prosecutor and you that your sentence should be community control or probation and being put into drug court, that's not binding on the court. So if you plead guilty, once I've heard all the information submitted at sentencing hearing, if I decide that's not the correct sentence, I could give you a prison term between 6 and 18 months, could fine you $5,000, could also suspend your license for 6 months to 5 years. You understand that?
Yes, sir.
Do you hold any license or certification from any state governmental agency that regulates any trade or profession in the state of Ohio?
No.
Right, now you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to counsel. Ms. Hatton was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So, if you decide you don't want to do this, that you would rather defend a charge and have her defend you, then that would occur instead of a plea. You understand that? Now, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that would be summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence would be presented. They'd be instructed on the law by the judge. And then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning the judge would be the one that would hear the evidence instead of a jury, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that would be to try to bring out evidence that helps your side of the case. You understand that?
Yes.
Now, under the Constitution and the laws of the state, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order, which is a subpoena, which forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court and testify against you. Do you understand that?
Yes.
Now, under the Constitution, you have privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial when you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, you are presumed innocent until proven guilty on every essential element of the offense charged by the state of Ohio. So what that means is that you're not required to try to prove you're not guilty simply because you've been indicted and charged. In fact, under the law, you're not required to present any evidence at your trial to defend yourself. You may, but you're not required to. But whether you do or not, the evidence, the state must still prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally you pled not guilty, which denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights that I've just described. If you change your plea today from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegations in the indictment and count one, admit that they're a crime, that you committed that crime, and that plea waives, gives up all the rights I've described for you today except your right to have counsel. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and to cross-examine through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state, would waive or give up your privilege against self-incrimination because if you say you're guilty, the state's not required to prove you're guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. And as I think I said earlier, it also would waive or give up your right to cross-examine and confront witnesses in open court. It would subject you to being sentenced immediately by the court. And finally, it would waive or give up any right to file an appeal on any alleged violations of your rights you think could have occurred up to this point in the case. Now, if I should sentence you to the maximum sentence, or under other limited circumstances, you can file an appeal. It would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
Are you a U.S. citizen?
Yes.
Now, do you understand the charge and the possible penalties?
Yes.
You understand the plea agreement?
Yes, sir.
You again understand that the court's not bound by the recommendation of the state and the defendant?
Yes, sir.
You have any? You understand the constitutional rights that I've explained?
Yes.
You have any questions at all about those?
No.
You understand the plea of guilty and what it means and what will happen if you enter that plea?
Yes, sir.
Is there anything you need to speak to Ms. Hapner about before we go any further?
Yeah, just one small thing.
All right. I'll put the two of you into a breakout room then. There it is.
When you're done with your breakout, I'll bring up here in just a second. Oh.
Huh. Okay. That's a different thing.
Do I hit join?
Yeah. Go ahead and hit join. When you're done, hit end or leave, and then you'll have to hit join again. Come back. Okay? Go ahead and put us on. It is. Oh, it's on. Spilled some stuff on it.
Well, once you rub it, you're on red.
Got it. All right. Ta-da. All right, we're back on record. Are we ready to proceed, Ms. Havner?
Yes, we are.
All right, then, and I forget if I asked you, but are you a U.S. citizen, Mr. Brigner?
Yes.
All right, is your decision then to go forward and enter a plea of guilty pursuant to the terms of the plea agreement we've just gone over to count one?
Yes, sir.
All right, then as to the charge, which reads that on or about June 17, 2024 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03, a Weather High Rise Code, a 4-3 felony, carrying possible prison term 6 to 18 months and a fine of $5,000 and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this date open court, the defendant is advised of all his constitutional rights, made an intelligent voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted, order filed, defense found guilty of count 1, count 2 is dismissed. Court refers the matter to the probation department for a pre-sentence investigation. The court will also order that include a assessment for substance use disorder and mental health issues. The case is referred to the drug court for consideration by defendant and the probation department. Bond will be continued, and we'll have a hearing, sentencing hearing on February the 5th, 2025 at 9 a.m. All right, is there anything further from counsel?
Yes, Your Honor, he's already had his assessment for drug court, and Mrs. Sturgill has made me aware that they have a bed available for him at the Recovery Council tomorrow.
All right.
So we would ask that he be released to go to that facility.
Any objection by the state?
No, Your Honor, I was going to let the court know the same.
All right. All right, so Mr. Brigner, I'm going to reduce your bond to an OR only. But that is on the condition that you remain, is it TRC you said?
Yes.
At TRC during the pendency of the hearing, and if you decide you don't want to be there and you leave, you have to come back to jail.
Okay.
And if you do that, that will not look good for you if you leave and don't come back. So you have to comply with those conditions, all right?
Yeah, I understand.
All right, thank you. All right, Rachel Button. All right, it's case number 23 CR 76, State of Ohio versus Rachel L. Button. Are you Rachel L. Button appearing there from the jail?
Yes, sir.
All right, this is a final pretrial, I believe, being conducted by Zoom. Trial set for January the 30th. Appearing on behalf of the state is Prosecutor Collins. Appearing on behalf of the defendants, Catherine Hapner. Defendant's charged with forgery and theft. Like I said, this is a final pretrial now. Is discovery complete from both sides?
Yeah, I have not filed my compliance, but we have an agreement. I just need to get back out to see Mrs. Button to get her to sign the plea form.
Oh, okay. All right. You anticipate doing that in the next day or so?
Yes,
Okay.
I had intended to fax it out today and just got caught up in other courts.
All right.
So I imagine by the end of the week I'll have that back.
All right. We'll set for plea then. All right.
Okay.
All right. So as soon as we get your plea form back, Ms. Button, then that'll be set for trial. Set for hearing. So, all right. Thank you.
Thank you.
All right. Is that everybody in jail then?
One more, Your Honor.
We go to Nikki Grant.
Oh, Nikki Grant, yes. Yeah, okay. And who's her attorney? I didn't see her there. All right. I have two cases before the court involving the same defendant. Case number 24 CR 101, State versus Nikki N. Grant, and 24 CR 171, also State versus Nikki N. Grant. This is pre-trial being conducted by Zoom. Appearing on behalf of the state's Prosecutor Collins, appearing on behalf of the defendants Catherine Hapner. And are you, Nikki N. Grant, appearing there from the jail?
Yes, sir.
All right, now I have a plea form here for case number 24 CR 101. But she was just arraigned, I think, recently on the 171 case. So what's the situation there, counsel? I don't see any reference to it in the other case.
Yeah, I spoke with Ms. Grant yesterday, and she's prepared to enter a plea on the 101 case. There may be a defense on the failure to appear. I don't know yet. I'm awaiting. Ms. Grant was in the hospital, and I just need to get those hospital records to see if those dates line up or not. I don't know yet until I get those records.
Yeah, okay. All right, so we're here on a bond review on the 171 is the only thing we're here for, actually.
Yep.
That's probably good that we wait on a plea anyway. I'm not sure if Ms. Hapner knows. I was just made aware during the lunch hour that Ms. Grant also has, if she hasn't been served, she will very soon be served with grand theft of a motor vehicle, a charge that Detective Butler from the police department is investigating that he interviewed her on.
Yeah, and thank you for making me that. I wasn't aware of that, so.
Is that just a charge through municipal court, or is it
I told him to go ahead and charge her.
Okay.
And to send the indictment up so that it can be indicted in January.
All right. All right, so we're going to go forward then with the 101 case, the plea?
I don't know if it makes more sense to maybe wait and maybe we can work out a universal resolution to everything.
I think that sounds reasonable. When's our trial date on that case? I don't know.
January 16th.
Okay.
The final pretrial is actually not till next week in that case.
Well, I think we moved it up for some reason.
Now, we're here for a bond review on the other case.
Yeah, we were just initially, I think, set for a bond review, but when I spoke with Nikki, she was ready to plead on the 101, so.
I'm looking at an assignment notice here that was filed on October 30th that said final pretrial 12/18 and jury trial 1/16. Did we move this forward for some reason, or just, I know, we're just here on the 171 case, technically.
Right.
My mistake. When I saw the plea of guilty, and then I thought we were also for that. So, okay. Well, then we have a pretrial next week for that. So if you want to go forward at that time, we can. If not, we can continue it until you have a time to review everything. There would need to be a speedy trial waiver, of course.
Yep.
All right. So for 24 CR 171, this is bond review. Do you have anything you'd like to offer, Ms. Hapner?
I've been informed that Ms. Grant has a bed available at Women's Recovery in Greene County. So I would ask if I can get a confirmation of that her bond be amended so that she can attend. It is an inpatient facility, but I don't have the bed date yet.
Is that from a court order?
It's from a case out of Greene County.
Oh, well, that's what I meant, a court order from there?
Oh, yeah.
Your Honor, I believe it's a detainer out of Montgomery County.
There's also a detainer out of Butler?
Oh, I'm sorry, it is Montgomery County case. It's Greene
Oh,
County
Montgomery.
Recovery, but it is Montgomery County case.
Okay. All right. Anything from the state?
Your Honor, I would just point out that this is for failure to review or failure to appear, so I don't believe the bond is egregious based on the nature of the offense charged and, you know, the length of time that we have been looking for Ms. Grant.
Well, in view of the fact that we have this case, we have apparently another one in the pipeline. This is a failure to appear back, I believe, in November. And on November 20th, she was supposed to be here. And she was indicted on December the 6th. And, I'm sorry, on December the 3rd, picked up, I believe, on the 6th. And so I know you heard some comment about being in the hospital, but you know, court's view is if you're on the hospital and the day of your hearing, you get out, you need to notify somebody. So, you know, you need to keep that in mind. And then given the fact that there's this other case coming down, I think I'm just going to leave it as is. So the bond will remain the same. All right. And then, like I said, if you want a continuance on the pre-trial, I have a problem with that, but we're going to need we'll need a a speedy trial waiver to continue this matter. All right?
All right.
Thank you. All right.
And then, Your Honor, I have one more, but who's not in custody, but I also have a hearing in juvenile court. May I be excused for a few minutes to go do that?
Who is it?
Tommy Shaman is the last one I have.
Okay, all right, that's fine.
But she's not in custody, but then I can log back in when I get back from
All
juvenile.
right, that'll be
That's
fine.
okay. Great, thank you.
All right. Case number 22 CR 245, State of Ohio versus Sylvia Cutler. This is a pre-trial hearing being conducted by Zoom. Ms. Cutler is represented by Danielle Witt, who is present from her office, present from the prosecutor's office, Prosecutor Collins. This is a final pre-trial. She's charged with aggravated possession of methamphetamine. The court received a fax this morning indicating that Ms. Cutler had entered the counseling center on 12/10. That would have been yesterday. And now I have received a statement from the counseling center that today, while their van was up here in town or somewhere, She was in the van being transported up here for the hearing. She took off walking while they were dropping off another client. And she's not present. She's not present there at the probation department, is she, Ms. Benson?
No, sir, she's not.
All right. And I assume you've heard nothing from her, Ms. Witt?
I actually did talk to her this morning, I believe, before she took off walking. I've been trying to get her in the office for a few weeks now.
All right. Well, the court will then order a capias to issue for her arrest, and case we put on the inactive docket
Second.
until such time as she is brought back before the court. All right, thank you. All right. You're Stephanie Eubanks there, appearing on the screen, Mark Eubanks?
Hello.
Hi, okay. Are you Stephanie Eubanks, appearing on the screen, Mark Eubanks? I need to hear you answer.
Yes.
All right. It's case number 24CR115, State of Ohio versus Stephanie Eubanks. It's a Zoom hearing being conducted pre-trial. Representing the defendant is J.D. Wagner, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. Defendant's charged in a 3-count indictment. This is the final pre-trial. Trial is set for January 13th. So where do we stand on this case, counsel?
Ms. Collins, may I? Your Honor, Ms. Collins and I have gone back and forth on this case, and I think we got a resolution now. My client's needs updated on that. We're not set till January 13th on our jury trial. Once I can get Stephanie in, Your Honor, and I think we'll accept the deal, I'll come over and get a plea date with Ms. Oyer, if that's okay with court, Your Honor.
All right. Sounds good. Stay in touch with your attorney, the probation officer, Ms. Eubanks. Sounds like if the negotiations are completed, there may be a plea next week or the week, a couple of days before Christmas. We'll want to get you in here. It has to be done before the end of the year. All right?
Yes, sir.
Thank you.
Thank you, sir.
All right. Officer Benson? DeLille, okay, sorry. DeLille. All right, this is case number 24CR155, State of Ohio versus John M. DeLille. This is a pretrial being conducted by Zoom. Mr. DeLille's attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. The defendant is indicted in, looks like, 4 counts, 2 counts of aggravated trafficking, 2 counts of aggravated possession of meth, plus a forfeiture specification. This is the first pretrial. Final pretrial set for the 8th of January and a trial date set for the 30th. I see the state has provided discovery, and you've received that in the bill of particulars, Ms. Witt.
I have, Your Honor.
All right. Your discovery will be due by the final pretrial. And do you anticipate any pretrial motions?
No, none at this time.
All right. And has there been a written plea offer made yet?
There has.
Is your client aware of it?
He is, and he's coming to meet with me this afternoon.
Okay. All right. Anything further than we need to discuss?
No, Your Honor.
All right. Then keep your point with your attorney, and you're due back here for your pretrial unless something results in an earlier hearing. We'll see you whenever that occurs. Thank you. Case number 24, CR 114, State of Iowa versus Joseph Bender. You're Joseph Bender?
Yes, sir.
All right, Mr. Bender is being arraigned on a 3-count indictment, receiving stolen property, aggravated possession of meth, and possession of fentanyl-related compound. Prosecuting Attorney Collins is present on behalf of the state. And Ms. Collins, has the alleged victim in count 1 been notified of the time, place, purpose of this hearing, the right to be heard?
Yes, Your Honor, and they have said that they will not be in attendance.
All right. All right, Mr. Bender, you're charged in count 1 with on or about August 1, 2024 in this county, receiving, retaining, or disposing of a 2013 white Ford F-250, which is a motor vehicle which you knew or had reasonable cause to believe been obtained through the commission of theft offense since it was property of another. So that's a 4th-degree felony, which carries a possible term of incarceration of 6 to 18 months and a fine of $5,000 if convicted. Count 2 alleges on or about August 1, 2024 in this county, you knowingly obtained, possessed, or used methamphetamine, and count 3 alleges on about the same date that you knowingly obtained or used fentanyl-related compound. Both those are 5th-degree felonies with possible sentences of 6 to 12 months and a fine of $2,500. And all 3 of those, or those two offenses also carry a possible license suspension of 6 months to 5 years. You're entitled to appointed counsel in this case if you can't afford to hire counsel, Mr. Bender. I see you have filled out a financial disclosure form and everything on here, correct?
Yes, Your Honor.
All right. You're not working?
No.
All right. Court finds you're indigent. Will appoint Attorney Jacob Wagner to represent you in the absence of counsel under not guilty plea. The court will set a bail review hearing for Monday morning, the 16th at 1:00 p.m. First pretrial will be on January 8th at 1 p.m. The bond review will be by Zoom, so will the pretrial. Final pretrial will be January 22nd at 1 p.m. also by Zoom, and the final pretrial will be in person, or I mean the trial date will be in person, obviously, February the 13th at 8 a.m. What's the state's recommendation on bond?
The state would recommend $15,000 bond. We would note that the defendant does have a extensive prior criminal history. This was indicted in October and he was just picked up. There is a victim in this matter. And he may be on post-release control. I'm not sure if he is off post-release control from his prior felony or not yet.
Are you on PRC, Mr. Bender?
Yes, Your Honor.
All right. Are you, have you received a sanction for that, or?
Well, I don't know.
Okay, you have. Okay, you just got picked up, right?
Yeah.
All right. Okay, Ms. Benson, if you could get Ms. Shaman in there. I see Ms. Hapner's rejoined us. All right, the court's going to set bond in the amount of $15,000 plus your own recognizance, which is your appearance or your promise to appear. And if you fail to appear, you could be prosecuted for additional felony. The court will note you have extensive criminal history plus a history of failure to comply. The court will require you pay a deposit of $171 for certain statutory required fees. You'll be under pretrial supervision of the probation department at 117 East Main Street, meaning you'll be required to report there immediately if you make bond. Report once a week for 4 weeks, and after that, as they determine, undergo random drug testing, provide phone numbers for home, cell, and employer, have no contact with the alleged victim as to count 1. And if recommended by probation, you'll be evaluated for substance abuse and mental health issues. If any treatment's indicated, you enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence, meaning you have to be there at all times, unless you're working, going to and from work. Medical appointments, court proceedings in this or any other case, appointments with an attorney, probation officer in this or any other case. Can also attend any kind of educational programming, job training, GED, college classes, etc., church services, and if you make bond, you can go to family holiday events. Otherwise, you have to be there at all times, and if you fail to comply, then court could revoke that bond, have you held to further order of court. All right, we'll notify Mr. Wagner of the appointment, and there'll be a hearing to review your bond on Monday afternoon at 1 o'clock. And the court will set that because I know that the prosecutors are out the next couple of days, and I'm out Friday, so that's the soonest that we can comply with the statute. All right, thank you. All right. you Tammy Shaman appearing there, Showman, I should say, appearing there from the probation department?
It's Tommy.
Tommy, I'm sorry, Tommy? You need to unmute yourself.
Tommy, unmute your microphone. There you go. Okay, you're good.
All right, you're Tommy Showman?
Yes.
All right. I have two cases here, 24 CR 117 and 24 CR 144. Both are set for pretrial. Being by Zoom, Ms. Showman's appearing from the jail, or I'm sorry, from the probation department, appearing from the prosecutor's office, Prosecutor Collins on behalf of the state. Catherine Hapner is appearing from her office representing the defendant. Defendant's charged with case number 117 with 2 counts of telecommunications harassment and with the same in 24 CR 144. This is a first pretrial, final pretrial set for January 8, and trial is set for January 30. Okay, looks like we did have, yeah, there was discovery provided in 117, and it's like, yeah, it's also in 144. You have the discovery, Ms. Hapner?
Yes, I do.
All right, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Yeah, I filed for competency, and that was all I really had. I mean, that has been done.
That's already been done, yeah.
Yeah.
Okay. Other than that, any other motions?
No.
All right, and has there been a written plea offer provided?
There has been. I have not gone over that with Ms. Shaman yet, but she does have an appointment at my office, and we'll discuss it at that point in time.
All right. We don't have to decide this today, but there are 2 separate cases indicted on the same charge. Is the state considering whether they would file a motion to join them for trial or not? Because if you are, you need to file that before the final pretrial.
Yeah, we will file that.
All right. So if you get that filed, then we can take that up at that time. All right. Anything further from counsel?
No, Your Honor.
All right, Ms. Showman, make sure you keep in touch with your attorney in reporting, okay?
All right.
All right, thank you.
You're welcome, Your Honor.
That's everybody, right?
It is, Your Honor.